this is a webinar on the Procurement Act 2023, and it is in particular a session for contractors or suppliers, so those who provide services to the public sector. We did a session that was more focused on public authorities a couple of months ago. The link to that will also come in the follow-up email that you get to this webinar. So if you are a public authority or if you're just a completist who wants to understand it from all perspectives, then you will get that. But notwithstanding the focus of today, if you are in public sector, you'll still be this will still be of interest to you, I am quite sure. So we'll move on. I'm Charles Livingstone. I'm a partner in the Risk, Government and Compliance team at Brodie's, and I head up our public procurement practice. And I'm joined today by Jamie Dunne, who is a legal director in the team and an accredited public procurement expert. So we'll move on to the substance. Here's what we're going to cover. So we'll give you a bit of an introduction to the Act. We'll talk about which bodies are covered and a little bit on what about Scotland. The what about Scotland part was covered in more detail in our previous public authority one. So we're not going to go into as much detail today, but as I said, you will have that other webinar available to you if that's a key issue for you. We'll talk about the timings for the introduction of the Act. We'll cover, in most part, we'll be covering the key changes, and we'll do a little bit about litigation. On the next slide, just before we move on to the substance, I'm going to set you a little challenge, and that challenge is, do you know what this is a picture of? And we'll come back to this at the end, so I will explain it to you. But if you know or you want to have a guess at what this is a picture of, then just put a message in the chat or put something in the Q&A or something like that. And I will all will be revealed towards the end. But if you think you know it, let us know. So without further nonsense from me, I'm going to hand over to Jamie to introduce the Act.
Thanks, Charles. So the Procurement Act 2023 is our new bit of legislation that we get to play with as procurement lawyers and procurement specialists. And that comes alongside a couple of other things. The Procurement Regulations 2024, which provide the sort of more detailed backup to the general regime that's set out in the Act. And then a huge number of guidance documents, primarily addressed at contracting authorities, public sector buyers, but potentially of interest to anybody else that wants to know how public sector buyers are going to behave once the new regime comes into force. The new regime was due in on the 28th of October, but for several reasons, which we won't go into, it has been delayed and is currently anticipated in the commencement regulations that have been brought forward to come in on the 24th of February 2025. So we've got a little over 3 months before that happens. And the new regime will apply to all public procurement exercises from that start from that date. So I'll on the next slide I'll explain, but effectively that's the D-Day, if you like, is the 24th of February 2025. As I mentioned, the procurement regulations will come in on the same day, and in particular, we'll make a lot more provision about the new transparency regime, which we will explore in a little more detail as we go. And what this does is it replaces previous arrangement of different regulations that covered public procurement. So the public contracts regulations, the concessions contract regulations, the utilities contract regulations, and then the defence and security public contracts regs. So moving on to the next slide, what will now be the landscape of public procurement, and in particular for suppliers to the public sector, is going to, I'm afraid, look a little bit very much more complicated. And effectively what you will be doing as suppliers to the public sector is operating under potentially as many as 4 different regimes, depending on what it is that you, what activities you are engaged in. So where the buyer, the contracting authority, is outside Scotland, then we will have the new Act, the new regs, and litigation in respect of that will be brought in essentially whichever court, the High Court in England and Wales or the High Court in Northern Ireland, if in Northern Ireland, to enforce provisions under those rules. For a rest of the UK, our UK contracting authority that's buying in Scotland, so that's the bottom left here. So think if the HMRC or any other UK government bodies, the central UK government departments, but buying things in Scotland, they will also be subject to the Procurement Act and the procurement regulations, but of course, litigation in respect of those purchases and procurements will be in the Court of Session. Turning to the top right here, where the buyer is a devolved Scottish contracting authority, which I will explain anon, then it will continue to be subject, its purchases will continue to be subject to the rules that are in force right now. So that is the Public Contract Scotland regs, and where applicable, the utilities contracts or concessions contract Scotland regulations, as well as some specific devolved legislation on procurement, the Procurement Reform Scotland Act and the Procurement Scotland regulations. Where those apply, litigation will be in the Court of Session or the Sheriff Court, depending on value. But those rules will continue to look exactly the same as they do right now, whereas the rules applying outside the UK and to UK bodies inside Scotland, sorry, outside Scotland and to UK bodies inside Scotland will be changing. And then there's a fourth category for those of you that are suppliers of things other than works to the NHS in England. There is going to be a regime, the Healthcare Services Provider Selection Regime regulations, and that regime, which I'll explain in a little bit more detail as we go, that comes with not your normal approach to litigation in procurement cases, but rather with an independent NHS review panel to look at complaints about procurements, and then potentially judicial review where you're unhappy with the decision of that panel, rather than something that would look more like a procurement challenge in the TCC as it would be in England. So moving on to the next slide then, which buyers are covered by the Procurement Act, this new regime that's coming in? So the Act defines a contracting authority. So a contracting authority has duties under the Act, and a contracting authority is either a public authority, which the colours are because I'm coming back to explain what they are, either a public authority or where the contract, which is to say the thing being bought, is a utilities contract. The contracting authority can be a public authority or a public undertaking or a private utility, and I'll explain what that means. So starting with public authorities, that is those bodies that are always subject in principle to the Act, whether an individual contract is or not will continue to vary. But for a public authority, the definition is really similar to where it has been, what we're used to. So a public authority is a person who is wholly or mainly funded out of public funds or is subject to a public authority oversight. So bodies that spend taxpayers' money or that are controlled by, have boards appointed by, etc., bodies that are government bodies, they are going to be public authorities where they do not operate on a commercial basis. Where they do operate on a commercial basis, then their money will be coming from that, but they will still be subject to public authority oversight, and so they will be public undertakings. So your key distinction really is going to be between a public authority that is commercial and a public authority that is not commercial, which is therefore a public, which is commercial, which is therefore a public undertaking. And a public undertaking is only caught where it is buying a utilities contract. And then there's this third category where where it's also caught if it's buying something that's a utilities contract, and that is a private utility. So it's any person that is not a public authority or a public undertaking, but that is carrying out a utility activity. And I'll come back to what is meant by utility activity in a moment. Those are private utilities, and they are covered only when they're buying utilities contracts. This is all very similar to what it is at the moment. The language has changed. Some of it's a little bit easier to understand, but in principle, the substance looks very similar. Then we've got this category of carved out people that would otherwise be public authorities or public undertakings who are excluded authorities. So what is an excluded authority? On the next slide, effectively, there are a couple of categories of this, and I'll go through them fairly quickly. But if you want more detail on any of this, then as Charles mentioned, our previous webinar to the public sector goes into this in a lot more detail, and you will be given a link to that at the end of today. So if you want more, you can have more. An excluded authority is any of the following. So a devolved Scottish authority, which is to say a person who has functions exercisable only in or regard Scotland, and none of those functions or only some of them relate to reserve matters, which is to say, effectively, if they are performing if they're performing devolved functions and they're exercisable only in or as regards Scotland, then they're a devolved Scottish authority. A public undertaking or private utility is treated as if it's a devolved Scottish authority for that purpose if it operates only in or as regards Scotland and none or only some of its activities relate to reserve matters. The definition of reserve matters, by the way, this all goes back to Scotland Act stuff. It's fairly detailed. We won't go into it just now. Excluded authorities also include any person subject to public authority oversight only by reference to a devolved Scottish authority. So if you are operating in perhaps, if the buyer is operating in perhaps reserved areas, but is only subject to oversight by a devolved Scottish authority because, for example, it is owned by a devolved Scottish authority, then it will also be an excluded authority. Excluded authorities also cover MI5, MI6, GCHQ, and the Advanced Research and Innovation Agency, or any person that's subject to authority oversight by one of those. Last point to make here is this one. Again, we do it in more detail in the other webinar if you want to see that. There are specific rules that apply to devolved Scottish authorities when they are using UK level frameworks or UK level joint purchasing or UK level dynamic markets and the like. So just be aware that depending on how things are bought, a devolved Scottish authority might bring itself within the scope of this new regime. So keep an eye out for that complexity. I said I would explain then what utilities contracts were fairly quickly, which is the next slide. A utilities contract is a contract for the supply of goods, services, or works, which are wholly or mainly for the purposes of a utility activity. What is utility activity? Much the same as what it was under the old regime. So specified in Schedule 4 to the Act, but effectively your sort of gas and heat supply is networks, electricity networks, water networks, transport, ports and airports, oil and gas extraction, that kind of thing. Provided that they're not carved out, because there are carve-outs in Part 2 of Schedule 4, and they're not carried on wholly outside the UK, and they are carried out pursuant to a special or exclusive right. What is a special or exclusive right? Well, this is where the buyer has been given the right to carry out the utility activity under some sort of statutory, regulatory, or administrative rule, and that limits the ability of others to do the same thing, as long as it wasn't carried out, given to it under a competitive process. So think about franchisees here, people that are operating railways or bus routes would in principle be caught because if they've got the franchise, nobody else can have it. But if they're given the franchise by a competitive process, then they're carved back out again. Key point really is who is a utility is very similar to who it has been in the past, and the rules will continue to apply to utilities much the same as they did before. So if you're supplying a lot of utilities, the new rules are not really going to change which utilities are subject to these rules in either direction. It's going to look much the same in terms of who your buyers are. Concessions also very similar to the existing rules. In terms of timings, going on to the next slide, the Act does not apply. So this is in the commencement rules. The Act does not apply where a contract or framework was concluded before the Act commences, or the authority contacted an operator to commence a direct award negotiation. So effectively, if the processes If the contractor framework is done, or there's a direct award underway, then the Act won't kick into force on that. It also won't apply where a contract notice was submitted for publication before commencement or where a VEET notice was published before commencement. It won't apply where a PIN notice was published as a call for competition before the 26th of May 2023. They've not been able to, buyers haven't been able to do that since then. And then there is specific provision for direct awards that follow on from the previous regime procurements and specific provision for utilities and concessions. So there will be a period where the existing rules will continue to stretch out their effect, even as the new rules start kicking in. And so you may, for example, have contracts under frameworks that are under the current rules that last for years into the new regime. So there is going to be a period of added complexity, as if there wasn't enough complexity here, added complexity as the two regimes overlap for a few years. So what are the key changes then? I'll get us started on this and then I will hand over to Charles. So key changes, first of all, a quote unquote single set of rules that replace the public contracts, utilities, concessions, and defence contracts regulations. I put single in inverted commas here because while it's a single set of rules in the Act and the regulations, they do apply differently depending on whether what is being bought is a public contract, a utility contract, a concession contract. So just be aware that it's not standardized across all of these things. They do work differently. Then there's this, as I mentioned a minute ago, this particular issue for those of you that are supplying the NHS in England. Regulation 43 of the 2024 regulations disapplies the Act in relation to regulated health procurement. So what is regulated health procurement? Well, it's fiendishly complicated, but in summary, it's the procurement of goods or services, not works. If you're somebody that provides works to the NHS, building hospitals, building civil works associated with hospitals, this isn't you. This is for people that provide goods or services to a relevant health authority, where that's subject to provision made under the National Health Service Act 2006, which is about procurement of healthcare services, whether or not that's in force. As I said, it's complicated, but the key point is if you are providing ambulance services, blood banks, residential nursing care, associated goods, medicines, all this kind of healthcare service and goods to the NHS in England, then there is a specific regime that applies instead to those purchases. And that is the Healthcare Services Provider Selection Regime regulations. I mentioned a moment ago that there's a different approach to enforcement of those, but also the rules themselves in terms of procurement are a little bit different. There's more scope for direct awards to allow for patient choice. There's more scope for prior contracts to be repeated, effectively saying, our current supplier is good. We're going to carry on with them for longer. We're not going to reopen this. There are similar rules on modifications, exclusion, and selection criteria, and there are still overarching duties to act transparently, fairly, and proportionately. Which takes us on then to the principles that we used to know and love under the procurement rules and that we still will in terms of devolved Scottish procurement. So those principles, equal treatment, non-discrimination, proportionality and transparency, they are not in the same way. They're not in the new Act. What we instead have is procurement objectives and a duty to have regard to these things. So your public sector customers will now have to have regard to the following: delivering value for money, maximizing public benefit, sharing information, and acting and being seen to act with integrity. There are, as we will come back to in a little bit, a lot more specific transparency duties on the public sector now, but no overarching duty of transparency that sits on its own. And instead, really, what we have are these sort of woolier objectives that public sector buyers are asked to take into account. There's a duty to have regard to the National Procurement Policy Statement, which will vary in different parts of the UK as well. Potentially, there will be a Welsh one, there'll maybe a Northern Irish one, as well as the national UK one. There's an express duty to consider lots under the new under the new rules, and the obligation to award a contract to the most economically advantageous tender becomes an obligation to award it to the most advantageous tender. What does that mean? Absolutely nothing. It's exactly the same as before. It's just that by getting rid of the word economic, the government hopes that buyers in the public sector will be encouraged to give more weight to non-price and non-economic features of a contract. Moving on then, we replace our previous 6 competitive tendering procedures with 2. So the open procedure, which is a single stage procedure where anybody's invited effectively to submit a tender, or the competitive flexible procedure, which is any other competitive procedure that the authority thinks is appropriate to the circumstances, appropriate to what it's buying. What you can therefore expect is more variety, especially as time goes on, in what the procedures, when what type of procedure is being used by public sector buyers. At first, we will probably see a lot of things that look very similar to the negotiation procedure, but over time, there will be more room for buyers to play with what those procedures look like. What they do have to do is make sure that whatever they choose is proportionate to the nature, complexity, and cost of the contract. So if you are bidding for a fairly straightforward contract, they should not be running an incredibly complex procurement procedure. Conditions of participation is the new name for selection criteria. They are effectively the same as selection criteria, except that there are now more rules about what buyers can require you to put in place before contract award. So in particular, they can't require your accounts before the end of the process. They can't require insurance to be in place before the end of the process. Exclusions, we start with on the next slide. The concept of an excluded supplier replaces mandatory exclusions, and an excludable supplier replaces discretionary exclusions. Otherwise, they are very similar. There are additional grounds, particularly relating to, first of all, improper behaviour, and secondly, relating to past performance. Public sector buyers will be able to take a lot more account of previous failure to satisfactorily run a contract than they used to be able to take into account in procurement exercises. There will also be a central debarment register maintained by the UK government with effectively a list of suppliers who have, for example, got certain convictions or been subject to certain enforcement activity and therefore are just barred from all public contracts up and down the country. There'll be more flexibility for public sector buyers to modify procurements up to the tender deadline in an open procedure or the participation request deadline in a competitive flexible procedure, although they will have to republish the notice if they do these things. Dynamic market replaces a dynamic purchasing system. It's not just a change of name. There used to be a rule that said that a dynamic purchasing system could only be used for simple procurements, pencils, but not for anything massively complicated, digital transformation. That did not stop there being such a thing as a digital transformation DPS. So those rules were honoured perhaps as much in the breach as in the observance, but nonetheless, those rules are now gone, and dynamic markets are going to be a lot more broad in their potential scope. Open and closed frameworks. So we've still got the old-fashioned closed framework of up to 4 years or 8 for utilities, but now this new idea of an open framework, which can go on for longer. So a public sector buyer can set up an open framework for up to 8 years. And what they have to do if they want to do that is they've got to reopen it to let more people on if they meet the conditions and if they satisfy the criteria within the first 3 years of that framework, and then again within 5 years from that first reopening. So there's a lot more scope to put in place longer term frameworks as long as an opportunity is given for new suppliers to join that framework effectively halfway through. And then there's going to be a central register of dynamic markets and frameworks, central register of a lot of things, as Charles is about to explain to you. Transparency is the name of the game. And with that, I will hand over to Charles.
Thanks, Jamie. I've had a few questions in, so Jamie, you can start thinking about the answers to those. If you have any questions from what Jamie said or from what I am about to say, then do put those in the Q&A. We'll hopefully have time to pick up a few at the end. So standstill is changing. At the moment, it's 10 days. That's going to change to 8 working days, which is a neater way to get to more or less the same timing. But that begins with the publication of the contract award notice, not with the issuing of a standstill letter. So that is potentially later in the process that standstill period actually kicks in. And that may be relevant for reasons we'll come back to. As Jamie mentioned, there's a lot more transparency around the Act in terms of notices. So some of these are kind of the notices that get published at the moment, but some of them are new. Pipeline notices, so larger public authorities will need to publish a list of all their planned procurements above 2 million for the coming financial year, not unlike obligations that Scottish public authorities already have. Tender notices, self-explanatory. Procurement termination notices. Authorities will have to put out a notice explaining why they have terminated a procurement. If they do that, that's new. Contract details notices. This is new. So this includes supplier details, details of options and renewals, any KPIs imposed in relation to a contract. So you as a supplier, there's going to be a lot more information about certainly your contracts and possibly about you in the public domain as a result of the Act. And indeed, if the contract value is more than £5 million, then the entire contract has to be published, which obviously is quite extreme from a transparency perspective. Authorities also have to publish payments compliance notices. These are just kind of like annual updates on how many invoices they paid within 30 days, 31 to 60, after day 61. That's just kind of publicity to almost name and shame slow payers, I suppose. Contract performance notices. So if an authority has to set KPIs, which it does for contracts worth more than 5 million, it must report annually on the contractor's performance against those KPIs. So again, a lot more transparency about you as the contractor. And then contract termination notices. Those will state if a contract has been terminated and the reasons for that termination, including the details of any breach or failure to perform. And that's going to be particularly relevant connecting back to what Jamie said about exclusions, because if a contract is terminated for poor performance, then that can result in exclusion from future public procurements. So on the next slide, some other changes, implied terms that the Act imposes into contracts. So authorities have to accept and process electronic invoices, have to pay any valid, not disputed invoice within 30 days or later if it's a later payment date. Any dispute or alleged invalidity about an invoice has to be notified without undue delay, and the authority can only rely on payment to a third party with the agreement of the payee. So these are all quite contractor-friendly, supplier-friendly implied terms. The second to fourth terms will also be implied into any subcontract. So if you're a main contractor, you should be aware that these terms will also be implied into your subcontracts if those are substantially for the purpose of performing or contributing to all or any part of a public contract. And also into regulated below threshold contracts, which are another concept, but we're not going to get into those. These terms can't be contracted out of. There's also, this isn't new, but an implied right for an authority to terminate if a termination ground applies, meaning that a contract was awarded or modified in breach of the Act, or if the supplier or subcontractor has become an excluded or excludable supplier. So that basically means that feeds the statutory controls through into the contractual mechanisms. Then we come on to the Procurement Review Unit. So this is an innovation. It's been set up within government to investigate and monitor the compliance of public bodies with their procurement obligations. Splits largely into three different categories or three different work streams. One is the Public Procurement Review Service, which is intended to investigate public sector processes in response to supplier complaints about specific procurements. And it will then issue non-binding recommendations to improve standards, and it will also handle cases concerning late payments. So if you are a supplier and you're concerned about how procurement was conducted, but you think, I either don't really have grounds for a court case, or I'm really not minded to take a court case, then the procurement review unit maybe gives you a little bit of comfort, a little bit of a route to try and improve things going forward. The Procurement Compliance Service will investigate systemic and institutional non-compliance, and then the Debarment Review Service owns and maintains the central debarment list that Jamie mentioned, and it investigates debarment against the majority of exclusion grounds. So basically, it's essentially a blacklist. So authorities don't need to do their own diligence on all of their bidders. They can largely just check the debarment list. And if you're on that, you have to deal with the procurement review unit to get off that. You don't deal with individual contracting authorities. Next slide, something that's going to be particularly relevant to suppliers and where there will be a big change. Not necessarily where direct awards are permitted, but in terms of transparency. So we'll come back to transparency. In terms of when direct awards are permitted, that's allowed as long as the supplier isn't excluded, although you can still make a direct award to a supplier if there's an overriding public interest, even if they are excluded. The authority has to have considered whether the supplier is excludable, and subject to ticking those boxes, a direct award justification has to be available, and those are in Schedule 5 of the Act. Those are substantively very similar to the grounds on which direct awards are permitted under what we've called the old regime, so the current regime and the regime that will continue in Scotland. The primary change is that extra goods, services, or works under an existing contract can now be direct awarded where that contract is within the last 5 years, and that previously it was just 3, as long as the original tender documents or notice identified that possibility. So slightly longer time frame for that particular direct award justification. There's also a new justification, so there's a new ability to make a direct award to protect life or protect public order or safety. You might call this the Matt Hancock rule. That's essentially what the government got into trouble for doing during COVID because there was no equivalent carve out for these sorts of direct awards in the current regulations. Next slide, contract modifications. So related to direct awards, this is where you have an existing contract and it's being changed rather than having a new contract be awarded to you. Although the rules around modifications, as I'm sure you'll know, is that if you modify a contract in a way that isn't permitted, that's essentially treated as a direct award. So under the Act, modifications are permitted where a permitted modification ground exists, and that's in Schedule 8 of the Act. Or it's not a substantial modification, or it's a below threshold modification, and that's the threshold at which a contract is subject to the Act's rules to begin with. So again, the rules on when modifications are permitted are very similar to the old rules or the continuing Scottish rules, but there is some additional clarity. So if you are looking to modify a contract and there is a ground available that would justify the direct award of a contract, then you can make that modification, and that's quite welcome because there was a lot of overlap and a lot of similarity between the direct award rules and the modification rules, but they were never written in exactly the same way, which made it quite hard to have absolute confidence that one necessarily mapped onto the other. But under the Act, that is easier. A new modification is the existence of a known risk. So if there's a risk that could jeopardize performance, but that could not be addressed in the contract itself, then as long as that risk was identified in the relevant notice as a risk that may result in modification, then in the event that that risk arises, the modification can be permitted. It's quite hard to sort of game that out in your mind, but I'm sure we'll see some of those develop over time. In terms of what's a substantial modification, so again, we have a bit more clarity on this under the Act. So it's not substantial to increase or decrease the term of a contract by up to 10% of its original maximum term. If anything, that's possibly more restrictive than the current rules, because I think the current rules you can probably read as allowing more expansive term changes than that, but this at least provides certainty. And then in terms of value changes, there's a 10% fluctuation permitted for goods or services, 15% for works. So the value can move up or down by 10 or 15% as the case may be, and that will be permitted. as long as aggregate modifications made to the contract are below the contract threshold and there's no material change to scope. That material change to scope is still quite a vague concept, doesn't really move us on from the current regulations, but we do at least have clarity on some other issues. So those are the rules on direct award and contract modification. Not massively different, but because if you are a supplier, the main thing you're going to be concerned about is the additional transparency around those, and that's covered on the next slide. So if a direct award is to be made, a transparency notice has to be issued before making that direct award, except in our Matt Hancock situations. And that notice includes information about the contract, its value, the supplier, the reason for the direct award, and the estimated date it will be entered into. Now, at the moment, there is no such transparency in relation to direct awards unless you do a voluntary ex-ante transparency notice or you do a sort of voluntary contract award notice. So this is a big change that we are already seeing driving quite significant cultural shifts within our public sector clients. So in particular, in-house legal and procurement teams feeling that they need to get a much tighter grip on their commercial teams and surveyors and people like that who have the day-to-day responsibility for managing contracts and who are potentially direct awarding or modifying contracts without exercising enough control. This transparency is we think, going to cause a very significant cultural shift. And then similarly, in relation to modifications, a contract change notice has to be published before a modification is made. So in the current rules, even when you have to produce a notice for modifying a contract, that's an after the event thing. Now it's beforehand, with exceptions. So if it's non-substantial or below threshold, then you don't need to make the contract change notice. There's a caveat to that caveat that I won't get into. A contract change notice can have a voluntary standstill period. It doesn't have to, but if it does, it has to be at least 8 working days. And there is a duty to publish either the contract or the modification if the contract's value exceeds 5 million, and that's either its original value or as modified. So in both of these cases, this additional transparency really does restrict what public authorities can do on a sort of one-to-one basis with suppliers. And we think this is going to be probably the biggest change that the Procurement Act is going to bring in, if only because it's going to cause significant cultural changes within public bodies who are going to be far more reticent and probably much more bureaucratic about their approach to making direct awards, and I think in particular modifying contracts, which is where there's probably been the most willingness to kind of sail close to the wind and take risk-based approaches is in relation to modifications. This transparency means that things have to be much more sort of by the book and documented. So in the next slide, I'll just say a little bit about litigation. So most of the duties in the Act are enforceable. So the main ones that you'll probably be relying on if you're challenging are the duty to have regard to the procurement objectives and the equal treatment duty. The National Procurement Policy Statement is not an enforceable statement, so that's not something that can be litigation. As long as you're a United Kingdom supplier or a treaty state supplier, which means you're basically from a country that is party to the government procurement agreement, you will have that duty owed to you and you'll be able to take enforcement action. But you can only bring proceedings if you've suffered or are at risk of suffering loss or damage. And under the Act, that litigation can be in the High Court, the Court of Session, or the High Court of Northern Ireland. Court of Session is underlined because at the moment, only cases brought under the Scottish procurement regs can feature in the Court of Session. The UK procurement regs, so if the MOD or HMRC are doing a procurement in Scotland, but they are doing that under the UK regs, that litigation still has to be in the High Court in London. So there will be potentially more procurement litigation in the Court of Session. And then there's a Good Law Project, again, going back to our old pal Matt Hancock. That's the name of the case where he was judicially reviewed for failing to comply with procurement legislation by a party that was not itself an undertaking entitled to take a procurement action per se. So that is still a potential risk. Automatic suspension, you'll probably be familiar with that as a concept. Now, the Act changes this so that you can't enter into a contract or modify a contract Well, the modification is new, the application of standstill periods to that. But you can't make a change or enter into a contract if during an applicable standstill period proceedings are commenced and the contracting authority is notified of that fact. Note that that is a change to during standstill. Currently, it's just before the contract has been entered into. So that does potentially create some complications, which we'll probably cover better on the next slide. Remedies are still split into pre and post contractual, and the procurement review unit I've already mentioned can investigate and make recommendations. So on the next slide, we have a side by side of the Procurement Act against the current regs and the continuing Scottish regs. So you've got the standstill changed, how that's calculated. At the moment, you get an automatic suspension if proceedings are issued and notified to the authority, although in Scotland they have to actually be served. And as I said, that's before the contract is entered into. Under the Act, it's if the challenge is commenced and the authority is notified. Now, I've said in this slide before the standstill period ends, but that's not actually right. I was correct on the previous slide. That has to be within the standstill period, and I'll circle back to that. At the moment, you have High Court, Court of Session, or Sheriff Court under the Scottish regs, High Court of Northern Ireland. Under the Procurement Act, you lose the Sheriff Court. Under the current regulations, you have 30 days to bring your challenge in most cases from the date when you found out about the grounds or should have known about the grounds. You do have 6 months if you're claiming for an ineffectiveness order, which is in our last line. But that changes a little bit under the Act. So under the Act, you have to bring your action 30 days from the date of becoming aware of the issue. The 6 months is now only a backstop for a set aside, for seeking a set aside order, and only in certain of the circumstances where you can seek a set aside order. Otherwise, it still runs from 30 days from the date of awareness that you have grounds for a set aside order. So that is going to be shorter. But really all that means that just reinforces the message we always give to suppliers, which is if you have a procurement issue, you need to get advice and support on that immediately, because the time will run out on you quickly, and indeed the clock may have started sooner than you think. So don't hesitate in getting support. Just connecting that 30-day point to the automatic suspension point under the Act. This is a thought I've had in the course of this webinar, so you're getting an exclusive. It seems to me that given that the automatic suspension only comes up if the challenge is commenced and the authority is notified within the standstill period, but the standstill period doesn't actually start until you have a contract award notice, you might have been notified of the grounds or found out about the grounds more than 30 days before the contract award notice, so before the standstill period even starts. So you might have to take your challenge prior to being in the window when you'll actually get automatic suspension. I'm not sure that was anybody's intention, but it seems to me that that's how it would work. The other thing about automatic suspension is if you don't get it after the end of standstill, that's going to create a lot of pressure to actually go to court sooner than you might have otherwise. Because at the moment, whichever side we're on, a lot of the time you'll get a voluntary extension to the standstill period so that everyone can just take a deep breath, step back and assess whether there is actually an issue. And a lot of the time, a challenger, even if they're not happy, will be persuaded that they don't necessarily have grounds for a challenge. If you lose the ability to get automatic suspension at the end of standstill, that creates a lot of time pressure to just get into court. Now, in theory, you could get a new standstill period through a new contract award notice, but that's quite a lot. That's way more bureaucracy than you have to go through at the moment to extend a standstill period. So next slide, key takeaways. The Act will change the way public bodies across the UK buy things, unless they're devolved Scottish authorities. So a whole spider's web of its own. There's some more flexibility, but there's significantly more transparency, particularly around contract terms, supplier performance, direct awards, modifications, etc. And a lot of established principles will be relitigated, even if only because words have changed and lawyers want to know if the word is the same, means the same as the previous word. Unhappy bidders will need to move even quicker if bringing procurement challenges, and the Scottish courts in particular are now likely to start facing two types of procurement litigation under two regimes, which is good news for the lawyers and probably for nobody else. Um, so uh, I'm just checking the chat and the Q&A to see if anybody had come back with. Nope, nobody's had a guess at what my picture is. This is Dagen H, which is the day that Sweden changed from driving on the left to driving on the right. And I sometimes use this image to talk about transition costs moving from one regime to another, because it looks like all the cars are driving into each other. Actually, what happened by all accounts is that the whole thing proceeded in a very orderly and very Swedish fashion. So hopefully the change to the Procurement Act will be very much in the spirit of Dagen H as it actually happened and not Dagen H as it appears on the image. So questions. We do have some questions. Um, Jamie, what's a working day for the purposes of the Act?
A working day anywhere in the UK. So it not necessarily bank. You don't just have to look at the bank holidays that are affecting the buying authority. You have to look at what's a bank holiday anywhere in the UK.
So it's more complicated than it needs to be, is the short
Oh
version.
yeah.
Um, the question, do termination notices only apply where the contract terminates early as opposed to its natural end date? The answer to that is no. So termination notice is obviously quite a loaded phrase, but actually it's contract expiry as well. So a notice does get published in any of those circumstances. Um, is there a timeline for publishing the transparency notice for the direct award intention? Jamie, do you know that off the top of your head?
You've got to do it before you make the direct award.
Hmm.
But
And I
I
think
mean,
it
other
comes.
other
I think the transparency notice comes with a standstill period
yeah
then attached to it,
yeah.
if I recall. Um, Jamie, you can take this one. Is there still an obligation to provide a standstill letter?
Yes, but they are now called assessment summaries, and there are
Yeah.
different rules on what has to be in them. But they're not what trigger the standstill period necessarily.
Yeah, which highlights my point. So your ground of challenge might arise from getting the standstill letter, but the standstill itself may not actually happen for some time.
Exactly.
Um, can authorities still procure from other authorities or connected bodies without having to run a competition? Yes, basically the sort of the Hamburg Waste, Tekal, etc. All those rules they're restated, so something may end up being litigated because they're written differently. But yes, the idea is that those rules will still apply. Um, Jamie, do authorities have to publish contract notices or indeed publish contracts even for call-off contracts under frameworks?
Yes. The what has to be published can vary slightly. But if, for example, you have a contract that's worth more than £5 million, then the contract has to be published whether it is purchased under a framework, if it's a UK framework, or if it's bought on its own. The exception is if the framework is a Welsh or Northern Irish framework, but that is far too complicated to get into in 20 to 30 seconds.
Yeah. We are running slightly over, but I'll just take one last question. You got 20. If you got another question you want to ask, you got about 20 seconds to ask it. Will contracting authorities have to or be able to redact commercially sensitive information from what gets published?
Yeah, so the general rules are about what the buyer has to publish are in the 2024 regulations, but Section 94 of the Act says that a contracting authority can redact commercially sensitive information. Watch this space, I guess, and watch this litigation in terms of what they are allowed to redact and what they aren't.
Yeah, what would have been helpful for Section 94 would be if it was written to match the freedom of information exemption relating to commercially
Asking
sensitive
far too
information.
much there, Charles.
Yeah, yeah, it isn't. And it talks about there needing to be, so your information is not just sensitive commercial information. There also has to be an overriding public interest in it being withheld from publication or other
Yeah.
disclosure, which is, as written, is a very high bar, but I imagine will be interpreted as there being a very strong public interest in maintaining the commercial sensitivity
Yeah.
of contracts. Otherwise, you're going to have suppliers deciding that it's simply not worth contracting with the public sector. And I imagine we may also see some challenges around that. So if you are a contractor, you're probably used to identifying parts of your contract that you consider sensitive for FOI purposes. Public authorities may start asking the same question in relation to Procurement Act publication. If they don't, and you're a supplier, you probably want to try and bottom that out as early as possible, and at least put the authority on notice as to what you consider to be commercially sensitive. We've run slightly long, apologies for that, but it did mean we got through all the questions. You have our details there. Do get in touch if you had a question that you didn't want to ask in open forum, and you'll get these when you get our follow-up. The next webinar that Jamie and I are doing is on changes to the merger control and competition investigations rules, not necessarily relevant to everyone in this audience, but particularly if you're in the construction sector, how the CMA investigates competition breaches, you're very much in their spotlight, so do sign up for that. But otherwise, thank you very much for your time, and we hope to see you soon.
Thank you.